you may be able to beat a charge of dangerous driving occasioning grievous bodily harm if there is, firstly, insufficient evidence to prove your guilt. Now, this is where the prosecution cannot prove beyond reasonable doubt that firstly you were the driver, or that your manner of driving was dangerous, or that there was an impact as required by the legislation, or that the injury amounted to grievous bodily harm. Now, if they can't prove any one of those things beyond reasonable doubt, then a good lawyer will be able to write to the prosecution and formally request the withdrawal of the charge or the reduction of the charge to a less serious charge, for example, negligent driving. If they refuse to do this, a good lawyer will be able to fight to have the case thrown out of court. Now, the second way to beat the charge is through establishing what's called a specific defence. And defences to the charge include, number one, duress. And this is where you're threatened or coerced into driving in that manner. Two, necessity. And this is where you drove in a dangerous manner to avoid serious injury or death. For example, driving someone to a hospital in an emergency situation. And three, honest and reasonable mistake of fact. For example, that you had an honest and reasonable belief that your manner of driving was not dangerous. And in determining this, the court can look at a whole range of factors. They can look at factors connected with the management and control of the vehicle, for example, the speed or the way that you're driving, the road conditions at the time of the offence or alleged offence, that is, the time of day, how busy the road was, the type of road service, the weather and general area in which the vehicle was being driven, and if it had any mechanical defect which affected its use. For example, if the brakes didn't work properly or so on.